Yes.
But I'm seeking my lord's leave to mention EC-com number 515 of 2025 for seeking my lord's leave to make a correction in the affidavit in support of tabular statement. Lord, I must indicate my lord has passed an order directing me, since the execution was filed prior to 2 years of the expiry of award, my lord has passed an order upon me to have the same served upon the judgment debtors. But prior, at the time of service, when we were preparing everything for the purpose of service, we've seen that there is one typographical error in paragraph 36. However, the cumulation for the quantification that we've sought is correct. Just in the paragraph, the number has erroneously missed a few digits. We went to the department. The department said prior to my lord's leave, the department cannot make any corrections.
To be mentioned on Monday.
May I just hand over the order that was passed and the mentioning slip in support there. Extremely.
May I have your lordship kind leave to mention this matter, my lord? Lordship, the filing department has written this particular file for a minor mistake. There is a standing instruction for the department that every certified copy of the arbitral award should contain the full signature. And however, this particular case, Lordship, there is exceptional circumstances. The learned arbitrator in this case has dead. So hence it is not possible to get the complete signature right now. I'm seeking leave for the same. Lordship, the decree holder is also died. So I'm seeking leave to.
You're seeking two things: substitution of the decree holder, as well as your petition should be admitted
Lordship.
Without the full signature of the
Lordship.
sole arbitrator.
Lordship.
To be mentioned में लाके फाइल मांग के दिखाओ इसमें क्या है. You granted to file it. Award is of which year?
It, 2021.
21. You have the substitution application also with that.
Lordship. Grateful, Lordship.
Item number 1 for judgment.
The execution petition is disposed of with the following direction. The award debtor shall remit to the award holder the TDS amount of 54,06,844 and rupees 8,56,800 without any interest within 4 weeks from today. The award debtor shall be at liberty to approach the income tax department seeking recovery, refund of the said amounts in accordance with law. In view of the above direction, the execution petition stands disposed of.
Grateful.
Fifth है ना? Yes. Call out the list.
Well, I'm appearing for the petition, my lord. My lord, this matter has been settled between the parties, and I'm praying for to withdrawal and proper instruction for.
Learned counsel for the petition states that the present matter has been amicably settled between the parties. She prays to withdraw the present petition. The same is dismissed as withdrawn.
And my lord, all
All
orders
interim
will be
orders, if
vacated.
any, stands vacated.
Grateful, lord.
Hello, my application under section 29A.
My lord, as per the last day's direction, my lord, I have got the affidavit in opposition, which was affirmed long back and served to my learned friend also long back on 20th January 2025, my lord. So may I just file it before the court? I have no objection to the extension of 29A, my lord, but it may be noted that there is an CIP process already ongoing.
No, should reject it. Plan has been rejected. My lord,
The liquidation application is still pending as on date. There is no bar as such of the extension of 29A.
What is the purpose of getting it extended when the moratorium is
my lord, provided the moratorium is extended, there's nothing on record to show that it has been extended beyond it was extended last time. If your lordship takes the
my lord,
opposition
take
file-
the IBC laws. Once the CIP process is started, my lord, first the IRP is appointed, then it becomes the RP. And if the resolution plan fails, then the liquidator is appointed. In this case, my lord, the liquidation application is already on board, my lord. So I have no objection to the extension of 29A, but the arbitration technically
what
can't
is the
proceed.
point of getting this extension done?
My lord, it can be adjudicated at least what is my claim.
It can't be. If the moratorium is there, it can't
Moratorium
be.
is not extended. That is
Can't
admitted.
explain this
That's
to
what
my
she's-
learned friend since
The liquidator has been appointed.
Lordship
Where's
will
the
kindly
question of-
take her opposition paragraph 4.42.
My lord, this opposition was affirmed in 20th January 2025, my lord. Thereafter, the matter was not
Let
taken up.
them produce an order where moratorium has been extended. Why is she taking such a plea? It
I
was
have
extended.
not
The
taken
order is
any
on
leave.
record.
My lord, let this extension be done.
Why is she making such submission when there is nothing on record to show that the moratorium has extended? Why this plea is taken?
You file your, learned counsel for the file an affidavit. Learned counsel for the
Further supplementary affidavit, my lord.
learned counsel for the respondent. Judgment letter states that moratorium has been seeks and is granted. Time to file supplementary affidavit, bringing on record the orders passed by the NCLT, right?
NCLT.
NCLT to showcase that the moratorium is still subsisting. Let's just say within 2 weeks kar dena. Within 4 weeks kar dena. Within 4 weeks additional affidavit. List after 6 weeks.
Much obliged, my lord.
Affidavit of taken on record. Affidavit in opposition taken on record. So you have already filed the affidavit in opposition
Yes, my
in the
lord.
registry?
My lord, this is the affidavit in opposition technically should be filed in court, not with the department. That is what the department told me.
So you say you had already filed it earlier.
My lord, it has been affirmed and it can't be a separately number. It has to be filed before the court
Taken
itself.
on record.
Affirmed on 20th January and served as well.
They have served us, my lord.
We have served it on 20th.
My lord, in item number 3, I am for the petitioner, my lord.
Lord,
Moina Ghosh is appearing for the petitioner virtually.
my lord, am I audible, my lord?
Yes, Mr. Boss.
My lord, this is a application under section 36, subsection 2 of the Arbitration Act
Yes.
for furnishing security for stay of the arbitral award. My lord, we filed a setting aside application which is also appearing in your lordship's monthly list within the period of 3 months from the date of passing of the award. My lord, this is a money award which we wish to secure.
Yes.
My lord, the award starts at page 11. The operative portion of the award is at page 43. My lord, we have computed the amounts which has been awarded by the arbitrator, and that computation your lordship will find based on the operative portion of the award. The computation is at paragraph 19 at page 7 of the petition.
Just one second. Page?
My lord, para 19, page 7 of the petition. Based on the awarded sums and interest, my lord, we have computed the sum, which your lordship will find at page 7 of our petition, paragraph 19. Well, the total figure according to us awarded comes to about 36,90,000, which we wish to deposit as a condition for stay of the arbitral award.
Yes.
This amount today, according to us, comes to 42 lakhs, 5,000 odd, my lord. And I'll leave it upon your lordship, whatever your lordship wants to, my lord. I think 40 lakhs, my lord, you should at least put in, my lord, because this is November, my lord, and there are certain places where they've calculated till August. So, my lord, your lordship kindly consider.
Deposit the money, Mr. Bose, 40 lakhs.
Very well, my lord, your lordship will indicate 40 lakhs, my lord. But because this calculation of theirs is, my lord, of course, it will be subject to the result of the setting aside. Very well, my lord. Very well. 40 lakhs subject to the result of the setting aside application.
All right, take it on. The petitioner has preferred the present application under section 36(2) of the Arbitration and Conciliation Act 1996, seeking a stay of operation and implementation of the arbitral award dated 12/8/2025, passed by the Learned Arbitral Tribunal, pending disposal of APCOM 842 of 2025. The 34 is APCOM 842, right?
My lord, 34 is the origin,
Number to
91 in the monthly list.
No, APCOM 842, right?
Yes, yes, yes.
842 of 2025.
842.
My lord.
In view of the submissions advanced by the Learned Senior Counsel, Mr. Mayanak Bose, and having regard to the facts of the case, it is directed that subject to the award holder, subject to the petitioner depositing the entire awarded amount together with the accrued interest, you calculate that and deposit whatever it is today.
Yes, very well, very well. We'll do that. We'll do that.
My lord, I'm sure
Let them do it.
and or else, my lord, then, my lord, your lordship has the discretion.
But it will be proper, my lord, if the calculation on the basis of which my learned.
But I can give it to him. We can come back tomorrow.
My lord, I'll take your lordship, and may I just indicate, my lord?
Yes.
If your lordship will see order 41, rule 3, my lord, it is subject to the satisfaction of the court. My lord, if your lordship feels that our computation of
Let us not go into that, my lord. And that has now to
So your
decide.
lordship gives us, may I just say this, my lord?
I'm
36,
saying it should be
90,000 is our calculation.
November.
Till
She
date,
indicates
Yes,
37 lakhs, we
I'm
deposit
saying-
37 lakhs. As a round figure, 37 lakh allow us to deposit.
Now 40 is also round enough, my lord.
Well, you cannot increase it at your whims and fancies. This has been computed based on the awarded
then
sum.
I have to record. If I'm
That-
recording the figure, then I'll say that the awarded amount along with interest is rupees so and so,
It is 42 lakhs 5,777.
is rupees 42 lakhs 5,007
777.51.
777.51 according to the award
Award holder.
holder. Full
Right.
stop.
which has been
Your lordship
disputed.
can, my lord.
According to full stop. क्या लिखना है? Learned Senior Counsel, Mr. Manak. Which according to the award holder is as on date is so such and such amount, ये जो amount बताया उसने, shall be deposited with the Registrar General of this court, Registrar original side, right?
Register original.
Registrar original side of this court, by way of cash security,
My lord, if I
Comma,
may pray
within a
for the
period-
indulgence, my lord, to buy,
no,
by bank guarantee.
no, cash security, within a period of,
Within 3 weeks. 1 week after the Christmas.
within a period of
vacation,
4 weeks,
Within a week
Four-
of.
4 weeks, sir,
Christmas,
within a period of 4 weeks,
lordship.
within a period of 4 weeks from date, there shall be there shall be a stay on the operation and implementation of the award dated 12/8/2025 till the final disposal of APCOM 842 of 2025. With the aforesaid direction, the present petition stands disposed of.
Obliged, my lord.
Petitioner डालना ऊपर जहाँ लिखा है ना award holder नहीं petitioner है.
Grateful.
Grateful.
हाँ disposed.
Lord, item number 4, my lord, I'm for the petitioner. It's a section 36 before your lordships in this item number. Now the 34 is also filed and appearing in your lordship's monthly list.
Yes.
Now, my lord, the difficulty here is that the service has not been complete.
Complete the service.
Yes, my lord. However, my lord, the difficulty is this, that we have served upon, we had served the 34 also on the same address that was appearing in the, my lord, the arbitral proceedings records. Now the 34 is returned back unserved, saying that the address is not found. Now the difficulty is...
Take steps to serve.
Very well.
Learned counsel for the petitioner seeks and is granted. How much time? 2 weeks?
2 weeks, or could it be 3 weeks?
3 weeks?
3 weeks.
3 weeks to effect service upon the respondents.
But 3 weeks will
After
take us
4
to the
weeks.
vacation.
After 4 weeks, that's fine.
Very good. Grateful, my lord. Grateful.
Your Lordship, this is my application. 5 is mine, 8 is yours.
5 is there.
5 is mine, 8 is 5 and 8 are connected.
Correct.
Your Lordship, I was praying if it could be taken up Tuesday. Today we are not ready with the matter because it has come up all of a sudden.
Might take a little longer, and I'll just indicate. 5 is their challenge to the award. 8 is my challenge to part of the award. Illegal termination of my agreement. Award of about 1.72 crores
In 5, affidavit in opposition has not been filed.
No, my lord. In 5, it's not been filed. I was not there that day. I don't think it's required to be filed. They haven't annexed any records, but whatever records that are there.
There's an order.
Yes, my lord. I see that we had prayed for a time to file the affidavit, but I don't think that will be required because the records are disclosed in my procedure.
Then I have to record that.
So that is if they don't want to press the 34 averments.
We'll file a supplementary affidavit in case if they don't want to file a opposition. We'll file a supplementary affidavit bringing on record the statement of claim, statement of defense.
That is there in my matter. But I'll indicate. Item number 8 is my challenge to the award to part of it.
Then make a, a convenience compilation set.
Which both parties can rely on. Well, in their item 5, they have only disclosed the award and nothing else. So whenever 5 and 8
then
are
you file
taken
your
up,
affidavit, bring everything on record.
it's there in item number 8. 8 is my challenge, partial challenge to that award. So if your lordship takes up 5 and 8 together today, 8 has everything. 8, I have to file an amendment application to my 34 application because inadvertently we've ended up saying, pleading that we challenge the entire award, which is not true. We challenge only part of the award where damages have not been granted to me. 1.72 odd crores have been granted in my favor that they have assailed by the item, by their 34, which is this item number. 8 is mine where my claim for damages for remaining 100 crores has not been allowed.
Not allowed. Okay.
So 8 has everything. My application.
Is there any direction in 8?
Yes, my lord, we were to file an application because we have to amend only that portion in the prayer where we've said we challenge the entire award. We'll be challenging only a part of it because the other.
Have you moved an amendment application?
No, my lord, that's being filed as I address your lordship now.
What do you want today?
That's
What do you want?
Maybe lordship keeps it sometime week after next. Then we can have it full-fledged hearing and finish it.
Award is
We
dated.
will be filing an opposition to their amendment application because substantially they are changing. So let it appear after a week, your lordship, subject to your lordship's
My
convenience.
amendment,
Thereafter,
my lord,
we'll because
I'll tell you lordship what the
Whatever it
amendment.
is, they want
when
to
the
file.
amendment application comes, then I'll make my submission.
Then your lordship keeps it on Tuesday.
Tuesday, your lordship.
Except that 5 and 8 be tagged together, my lord.
And my 36-2 application is
Item
also.
5 and 8. Learned
8.
counsel for the parties submit that both the matters are arising out of the same award.
Yes.
Let these matters be tagged together. Full stop. In item 5, record. Learned counsel for the respondent states that he does not wish to file his affidavit in opposition. Full stop. Though there was a direction, by an earlier order, there was a direction to the respondent to file the affidavit in opposition. He does not wish to file any affidavit in opposition. Full stop. In item 8, learned counsel for the petitioner states that he shall file, he is in the process of filing an application for amendment in the prayer clause, since he is partially in the prayer clause, right?
Yes.
In the prayer clause, since he is partially challenging the prayer clause, in the prayer clause, since he is partially challenging the award dated
6th August 2024.
6th August 2024. Full stop. Let the same be done within a period of 2 weeks?
2 days. It will be filed today. So I can
1
come back on
week,
Tuesday or
list
Wednesday.
after next week.
Great.
Like,
Minutes, item 5 minutes, I appear on behalf of the respondent. 6 minutes. I appear on behalf of the respondent.
6 is my application, Malad.
Yes, minutes. I appear on behalf of the respondent.
Yes.
May I place it, Malad?
Yes, Mr. Bandyopadhyay.
Malad, in this matter, Malad, most interestingly, Malad, the learned arbitrator, in spite of clearly holding that the claims are beyond the purview of the contract, has awarded claim under 2 heads, and that too purely on guesswork. He has held that the evidence which has been produced by the claimant are not substantial. In spite of that, almost in a sympathetic gesture, has given part of the claim.
You wanted to hear the 34, or they want to file their affidavit in opposition?
They are not making that.
Milot, there's no requirement per se. Milot,
Very good. Can you record that and I'll place it?
So we can hear it, I guess, then.
Yes, Milot.
No.
There are only two principal grounds on which Milot they're challenging or seeking setting aside of the award. Milot, one, they say that there is no concluded contract in view of the fact that Milot, the initial tender issued in our favor to construct the Ma flyover stood terminated, and Milot, the balance work has been completed by virtue of orders of Honorable High Court at Calcutta, before whom Milot, the termination was challenged. And Milot, the second ground is that Milot, the claim 3 and 4 of the
I
statement.
believe it is my petition. I can place my case unless my learned friend wants to pick up my brief also.
Of that.
Yes, but I'll give a short overview of the matter, Malad. But the construction of the Ma flyover, Malad, which is the flyover your lordships will find, Malad, while traveling from the airport, which is the longest, Malad. Yes.
Take it every day.
Yes, Malad. Malad, that was under construction, Malad, from 2009. Now, Malad,
Yes.
2 wings of that flyover, along with some parts of the main flyover, could not be completed within the stipulated time.
Yes.
Time was extended, and ultimately the part which could not be completed by the contractor was put to tender sometime around 2013. The contractor, which was the existing contractor, who is the claimant in this arbitral proceeding, they moved a writ petition before this honorable court challenging the tender for construction of the remaining part of the flyover. That writ petition was taken up by a single bench of this court from time to time from March 2014 to February 2019. Thereby, not only awarding the work to the existing contractor, finding that the existing contractor is already mobilized on the ground, they know about the site conditions, therefore it will be in public interest to give the work to the same contractor at a negotiated rate of 257 crores. This is by an order of 2nd of April 2014.
That is the company, Hindustan.
That is the company. That is by an order of 2nd of April 2014 by my Lord Justice Dipankar Datta.
2nd of April.
April 2014.
in WPA, in WP W7104W of 2014.
Where's the order?
Well, at page 43 of your Lordship's brief. Since it lays down various conditions for carrying out the work, and it is one of the very important documents in the arbitral proceeding. But if I may place it, my lord,
Yes.
page 43, if your Lordship got it, my lord.
Yes.
May place it.
Yes.
The project for construction of an elevated road corridor from Park Circus to Eastern Metropolitan Bypass near Porma Island has been entrusted by the Kolkata Metropolitan Development Authority to the first petitioner upon it being found to be the most suitable bidder in furtherance of a tender notice dated August 25, 2009.
Yes.
The several deadlines fixed for completion of the project have been passed by, with the project only near half complete. The petitioners alleged inability of the KMDA to provide encumbrance-free site work fronts as the main reason for jumping the deadlines, while the KMDA has cried hoarse that despite full cooperation from the side of the petitioners, lacked the intention to complete the project with the deadline that were fixed from time to time with an eye to earn more profits. Due to the disputes and differences that cropped up between the petitioner and the KMDA, the work related to the project has been stalled for a few months. I need not examine the issue of fixing responsibility at this stage since it is hardly relevant. Suffice it to note the relevant road corridor could not be made functional, resulting in the pain and agony of the public mounting to each passing day. The KMDA deleted a portion of the works from the contract by a letter dated so-and-so and issued a further tender on January 21, 2014 for completion of the balanced portion of the work, mentioning rupees 260 crore as the estimated cost of the work. The bid of the first petitioner at 293 crore was the lower between the two bids that were received. However, by an order dated 5th February 2014, the tender was cancelled. A fresh e-tender notice was issued on so-and-so, mentioning 257 crore as the estimated cost of the work. Cancellation of the tender notice dated January 21, 2014 and issuance of the fresh e-tender are under challenge in this writ petition. I have heard the parties at length over the past few days. The project is an ambitious one, and having regard to the fact that the elevated road corridor would pass through one of the busiest roadway of Kolkata, it is by no means an easy task. However, it is axiomatic that once the elevated road corridor is thrown open to the public, kindly skips over that part, the public interest part. Kindly comes to Malad. Last 5 lines.
Considering that examination.
Considering that examination of the legal niceties that were involved would only delay the project, which would not be in public interest. Further, having regard to the fact that the first petitioner had completed erection of the pillars on the stretch starting from the eastern end of number 4 pool to Spring Club towards the northern side of the Eastern Metropolitan Bypass with a partially constructed downward ramp towards the southern side, I had requested the parties to settle the disputes and differences across the table in my presence in the chamber so that the project work could resume and construction is completed at an early date, preferably by the next year end. Pausing here for a moment, not only this instance, at least 3 or 4 times more, the Honorable Judge had been pleased to call all the stakeholders to his Lordship chamber so that the work can be completed. Then 3. The parties were not ad idem on all the terms of the claims and counterclaims. The first petitioner in course of hearing proposed to carry out the balance work at the estimated cost mentioned in the e-tender notice dated February 18, 2014 and also to bear the expenses for removal of utilities subject to KMDA, providing the petitioners encumbrance-free site, work fronts and removing all types of utilities therefrom in a time-bound manner. The proposal was not acceptable to KMDA and the prayer for orders to proceed with opening of the commercial bids received pursuant to the e-tender notice dated February 18, 2014. By my order dated March 20, 2014, I had stayed operation of the impugned tender notice until further orders and placed the writ petition for further consideration. The parties have since been heard on a number of days in my chamber in the presence of technical personnel from both sides. At the hearing, I insisted that the parties must explore the possibility of completing the project and invited suggestions from them. Suggestions that were received have been duly considered. Bearing in mind the fact that the response to the tender notice dated so-and-so was not at all encouraging, and the KMDA has further reduced the estimated cost from 260 to 257 crores, and the petitioners are willing to complete the project at such cost and are agreeable to bear the cost of utilities subject to the conditions noted above, I am of the view that the proposal of the first petitioner is fair and reasonable. Further, considering the fact that the petitioners must be aware of the working conditions and ready with the drawings and designs pertaining to the project and would be in a comparably advantageous position to mobilize men and material, in my opinion, entrustment of the new contractor would only prolong the process, which is absolutely against public interest. Keeping the project work in an unfinished state would also add on to the miseries rather than benefiting anyone. The extraordinary situation demands that the parties should bury their disputes and differences for the present, and right intention should be backed up by right actions. Although this writ petition was not filed in public interest, it is the duty of the court to interdict and set the project in motion once again by making appropriate directions to ensure that the completion is not unduly delayed. Your Lordship will kindly mark the words interdict and once again by making appropriate directions. It is accordingly directed as follows. 1. Subject to further order that might be passed in course of this proceeding, if necessary, the terms and conditions of the balance work shall be governed by the letter of acceptance dated December 15, 2009. Modified or revised letter of acceptance shall accordingly be issued by KMDA as early as possible. On account of mobilization advance, 5% of 257 crores shall be paid to the first petitioner by the KMDA by April 15, 2014. This is not part of the original contract. Our contract did not envisage any mobilization advance. This is being incorporated as a dictum of the court. The balance work shall be executed. Then the schedule has also been given by the court itself, my lord, upon consultation of all the technical personnel. I am skipping over that part. Then 4, my lord, very important, at internal page 8, running page 50. Since the works has to be executed and completed as per the above work schedule, and within the stipulated time, the number of organizations, government departments would have to extend. Sincere cooperation and cohesive action is called for to ensure expeditious removal of utilities to provide encumbrance-free sites and unhindered work fronts to the first petitioner. A high-level coordination committee is hereby constituted with the Honorable Minister in charge of Municipal Affairs and Urban Development, Government of West Bengal, and the Chairman KMDA as the chairperson thereof, and consisting of the following members. But I am coming to the members, but kindly see the scope of the high-level coordination committee. Expeditious removal of utilities to provide encumbrance-free sites and unhindered work front to the first petitioner. With the object of these two, the high-level coordination committee was constituted, which includes, my lord, kindly takes Roman 10 in the high-level coordination committee, an authorized representative of the petitioner himself. Then, my lord, after the list of 13 personnel, if necessary, the engineers of the first petitioner and KMD and the officials of any other department of the government of West Bengal statutory authorities whose cooperation is likely to be required and whose presence is considered necessary may be invited to form part of the high-level coordination committee by its chairperson. It would be desirable if the high-level coordination committee meets at least once a month to take stock of the progress that is being made, as well as to suggest ways and means to achieve goals that is set by this order. Since vehicular traffic in and around the sites, then kindly skips over that part. Then the Kolkata police is also given certain directions. Number 5, cost towards shifting, relocating, restoring of all utility lines, including all cost of materials, labor, and disposal of unserviceable
Mr. Bandapade, this is going to take time.
A little time, because I'll have to place the orders of the writ court. But my lord, just my lord,
so let me do one thing. Just let me finish my board. There are very few matters on the board. Then I'll hear you for a while. And then we'll keep.
Very well. Or my lord, if I may come back in the coming week, also my lord, if your lordship gives me some time.
When do you want?
Any day, subject to your lordship. Monday, Tuesday, my lord, subject to your lordship, business permitting, my lord. Kindly give me a block of few hours, my lord, I'll complete it.
Gopal.
But my lord, if I may conclude today with one paragraph of the award, my lord.
Just
As a my lord, the
With a sweet taste, my lord, for me.
Yes, go ahead.
One paragraph.
Yes.
And it takes 972.
9,
972.
दूसरा वाला.
This is part of the award. Kindly, my lord, takes.
Yes.
107.
100, 107.
From where I started, paragraph 107. Kindly takes the. I don't find any such head in the contract as mentioned in claim 127, under which the contractor may be permitted to recover the losses for the reasons stated herein above. In that view of this case, it may safely be stated that the claims as has been stipulated in the statement of claim are beyond the purview of the contract, and there is nothing in the contract to refer the aforesaid claim to the claimant. Well, after this finding, my lord,
He has awarded.
he has awarded under for claim number 3, claim number 4, lump sum amounts, my lord. After that also I'll show, after holding that the evidence is not substantial. And one more finding kindly takes, my lord. The internal page 81 of the award. Running page to internal page 81, running page to
Internal page 81. Yes.
Kindly, my lord, from the top, 5 lines from the top. Kindly take the 6th line. My lord, is at 1001, my lord. In that view of the case. In that view of this case, it would not be fair to fasten the respondent with the liability of disruption of work of subject contract in view of the orders passed by the Honorable High Court. And their entire case is that there has been delay by KMDA. But after these findings of fact, there is no foundation for the claim to be awarded at all. I'll elaborate on that whenever your logic is matter.
Milods, the two claims which have been allowed, Milods, have been allowed on the principle that, Milods, the arbitrator is entitled to award compensation for delay in handing over unencumbered sites despite the contract barring such
The arbitrator is there to decide
claiming of compensation by the
in
respondent,
the
Milods.
four corners of the contract. Once he
And
holds
Milods,
claims are
all
beyond
the evidence.
Just a minute. That's the problem when you appear virtually.
The arbitrator is there to decide the dispute within the realm of the contract between the parties. When the claim is traveling beyond the contract itself, he loses jurisdiction to entertain that.
Award is which year? 20?
This is 30th October 2024.
Right, so we'll have it. There's no urgency as such.
If they do not file an execution, I have no urgency. To be honest, they have not filed.
Then we'll keep it in the monthly list of then January.
But kindly fixes a date, Malad. Kindly, Malad.
You're not filing an affidavit in opposition?
Milod, in the meanwhile, we'll file the affidavit in opposition, Milod.
I started because he said he will not file.
Milod, see, Milod, there is no requirement, Milod. Only points of law have to
record
be
that.
Milod, all record is there.
Malad, I'll say this.
I'll do it. I'll record it that you don't wish to file any affidavit in
Very
opposition.
well, Milod. Very well, Milod. That
Well,
may
if, Malad, I'll go to the extent of saying if my learned friend in the meantime feels that some document we have missed, he may indicate I'll file a supplementary affidavit bringing that document on record. And also the contract is probably not on record. Malad, kindly grants me leave to file a
kindly
supplementary.
allow me to file my opposition, Milod. If this is the state of affair, Milod, kindly allow me to file my opposition.
Current consulted respondent seeks and is granted further 2 weeks time to file his affidavit in opposition.
Malad, kindly grants me liberty to use a supplementary affidavit bringing the contract on record.
They'll bring it?
Very well.
Bring the contract on record.
A2, Milod.
If they don't, then
Volume A2. Volume A2.
if they don't do it, then I'll list after 4 weeks.
First annexure.
A1. রিপ্লাই তো দিয়ে দেবো আমরা ও এফিডেভিট দেবো আমরা রিপ্লাই দেবো তখন তখন দিয়ে দেবো
4 weeks. After 4 weeks.
Deeply obliged.
Grateful.
Some settlement talks.
Yes, my lord. We have not been able to conclude the documentation, but kindly give us,
We'll give some more time.
my lord.
Yes.
Learned counsel for the parties state that settlement talks are underway. They pray for an adjournment. Let this matter be listed. How much time you want?
4 weeks, my lord.
Months time.
4 weeks, my lord.
After 4 weeks. After 4 weeks.
Great.
Your Lordship, perhaps.
I'm being led by Mr. Bagh in this matter, my lord. We
Please, Your Lordship. I apologize at the very beginning, my lord. I am not there physically today. My lord, very briefly, my lord, there are two matters in the list, item 9 and item 10. My lord, item 9 is a
Perhaps has
section
no
34.
jurisdiction. Lordship, perhaps, my lord, subject to Mr. Bagh saying has no jurisdiction. Because if your Lordship sees your Lordship has jurisdiction to, my lord, set aside arbitral awards. Lord, please see page 54. Whether it can be considered to be an arbitral award or not.
That's the whole dispute, I guess.
It's, my lord, MSME, not signed by
I
the
understand what's being
arbitral
submitted.
tribunal.
If I can indicate, my lord,
Yeah.
kindly
And no
take up.
stamp paper.
My lord, may I submit to that? If that is the opposition on maintainability which is being taken, my lord, there are two. My lord, first, my learned friends have not filed a section 34, so I do not know on what basis, my lord, they can make this submission. There is no section 34 on board filed by my learned friends. Time is over. 120 days is over. So they have accepted the award. Had they, my lord, a point in law, my lord, with regard to the maintainability of the award, I'm sure they would have filed a section 34, especially when Mr. Chaudhary, my lord, is advising them. So that's not been filed. They don't have a section 34 on board. I have, my lord, section 34 because my claim was for 3 odd crores, my lord. 1 crore was awarded to us.
Preliminary
2 crores
point,
not awarded.
not signed. My lord, kindly consider the judgment of.
My lord, before my learned friend, my learned senior friend starts, my lord, may I only indicate
Yes,
this?
yes, please.
Today, my lord, there is no, my lord, challenge to the arbitral award.
Yeah.
There is, of course, my lord, an option open to the Honorable Court on an application which we can file, my lord, to send it back to change, challenge, my lord, any
25
grounds
onwards,
that they have taken. But I'm sure my learned friend will permit me to make my submissions.
Yes, yes.
My lord, section 34 is filed by us, section 36 is filed by us. So there is no section 34 filed by my learned
Mr.
friend.
Beg, why don't you come on Monday? We'll hear you when you're here.
My lord, I
It'll
can
be
do that.
better.
May I only pray, my lord,
He's
instead of
anyway in a lot of
Monday,
difficulty. My lord, it's better if he comes and does
I
it.
think that's
Otherwise, he'll go and
I
say,
am not
and
in any
there you
difficulties. I
steamrolled
can
me.
indicate that.
All of
But
them, you know, give me grief all the time. But may I request, my lord, for Monday week?
Monday week?
Yes, because next week is very uncertain for me. I may be here, but I also want to be here.
This is the best time when I make a prayer that Lord kindly keep it on next week without Mr. Chaudhary.
That's what he's also saying. At the
No, no.
request of the party.
He wants it on Monday.
No, I want it next week. Mr. Chaudhary is not there. So,
I'm
I'll come back whenever.
putting my learned friend on notice that I'm relying on. I've given your junior a copy, 2021 7 SCC 657.
Just show me, Mr. Chaudhary.
Paragraph 25 onwards.
Can we see that?
The legal requirement of signing the award. It says, my lord, award, my lord, has to be signed and has to be stamped. My lord, please see para 25 at page 669. Section 31(1) is couched in mandatory terms and provides that an arbitral award shall be made in writing and signed by members of the arbitral tribunal, authenticated by their signatures. This is paragraph 26. An award takes legal effect only after it is signed by the arbitrators, which gives it authentication. There can be no finality of the award except after it is signed. Since signing of the award gives legal effect and validity to it, the making and delivery of the award are different stages to an arbitration proceeding. An award is made when it is authenticated by the person who makes it. The award makes it obligatory for each of the members of the tribunal to sign the award to make it a valid award. The usage of the term shall makes it mandatory requirement. It is not merely a ministerial act or an empty formality which can be dispensed with. So, my lord, my learned friend at page 54, page 54, my lord, has come with an award which is not signed. It may not says SD. Trivia from the early days, I walked into the civil.
Where's the award?
Not 54.
It starts from page 28.
No, it ends at page 54. It
Yes,
says SD, Mr. H.K. Guho member, SD, Mr. B. Bhattacharya member.
Nobody has signed it.
Nobody signed it. At least it's what is given to us is not signed. That's the end of the matter.
There's a reason. Lord, kindly take up page
second.
27.
Award has to be on stamp paper. There's no stamp paper.
Yes, Mr. Beg, what are you saying?
Lord, page 27. That is the communication which is handed over. And your lordship will find the subject.
Where is the award?
This is the certified copy of the arbitral award. That's how it is addressed. That is page 27 from the Facilitation Council. Kindly see the subject. Certified copy of the arbitral award in matter dated this, enclosed herewith, find herewith the certified copy of the arbitral award in this. So they call it a certified copy, and I'll argue, my lord. I now know what the objection is. So
now,
I'll
second objection is this has to be stamped. And that's the second judgment I'm handing up.
Yes, yes.
150 rupees. 2003 8 SCC 565. Paragraph 4. And Millard, it's important, after we heard the matter, we are of the view that in the present case, this issue was not required to be gone into at the stage of proceedings under section 34 of the Act. In fact, this issue was premature at that stage. Section 34 of the Act provides for setting aside of the award on the grounds enumerated therein. It is not in dispute that application such and such. The question as to whether award is required to be stamped and registered would be relevant only when parties would file the award for enforcement under section 36. That's item 10.
I think Mr. Chaudhary, enough for today. For Mr. Beg.
So let him get over this and then we'll tell your lordship what his wonderful arbitration was about. Now the legal significance is, if ultimately I am ever served with, my lord, the stamped award signed by the members, that's when, my lord, limitation will start running for both 34 and for enforcement.
My lord, I'll answer to that on the next day when the matter is taken.
Yes. That's much better. You need to be here.
Yes, my lord. I will, my lord.
Only foreign books, my lord, behind him.
At the request of the learned counsel of the parties, let this matter be listed on next week, 15th. क्या डेट है when गोपाल डेट 15th 15th
Grateful.
और ये
This also, I think he's on the other side.
My lord, I'm appearing, my lord, in the matter.
This is
kindly permit me to come back on this as well. I'll come and argue
no, on the
physically.
15th, because Milord, this is a difficult matter for him. He's filed a 34 beyond.
Whenever Mr. Chaudhary Milord is on the other side, for me, it's always difficult.
Question is very interesting. Milord, arbitral tribunal during arbitration had set up a WhatsApp group, delivered award in physical form to everybody. Then Milord, under 33, it corrected the award, signed it, stamped it, scanned it, and sent it by WhatsApp to Milord everybody on that WhatsApp group. His advocate receives it, his client receives it. His client, who's the witness, receives it. From that day, if you take 120 days, his application is beyond time. The
Milord, may I answer that? Milord, today, I'll come back with judgments which I'm carrying.
I'm not passing any order.
No, no. Arbitral tribunal also sends a physical copy. From the day he receives the physical copy, he's within 120 days.
Yeah.
Now he's saying take that to be the date. I am saying take the WhatsApp as the date.
Is it good service? WhatsApp.
It's not, Milord. It's not.
And
I'll indicate from judgments it is not.
Any judgments?
There are judgments. I've come with them.
I'm carrying all judgments where it's not even a WhatsApp service. I should indicate this. What my learned friend should have shown.
Show me which is.
Electronic
it is not a WhatsApp
WhatsApp
service.
is electronic
communication. It's in a WhatsApp group. It's not a WhatsApp service. It's uploaded in the group. So that's where the distinction lies. It's not even a WhatsApp service, Milord. And I'll indicate that.
Interesting issue.
Interesting.
Very interesting.
Issue, definitely, Milord.
That's why I want my learned friend to be here, because if your lordship holds in my favor, his client will suffer.
Milord, I have judgments to indicate that this is not good service at all.
15th.
Sir, may I just put the reply on record?
Affidavit in opposition filed by the. But why reply right now? We have not even.
No, affidavit in opposition they have filed.
Well, there were directions.
Directions to 34 filed. I filed an IA for dismissal.
Yes.
To that, he's filed opposition. My reply.
Okay. Reply to the GA. All right. GMA Likhna, GA1. Reply to the affidavit in opposition filed by the respondent is taken on record.
Great.
I'm very deeply obliged. Your Lordship is pleased to keep it on the 15th, Milord?
15th.
15th. I'm very deeply obliged. Milord, I am Bag, not Beg, Milord.
Milord, he is the. Milord,
in Bengali, it is tiger. So, Milord, that is why my learned friend.
Milord, juniors say, Milord, he is the only qualified barrister in North 24 Parganas. Salt Lake.
I'm very deeply obliged, Milord.
If seat and venue is Kolkata and his revered father, Milord, is the learned arbitrator, we always tell him, don't call us there because that's outside jurisdiction.
We always have, Milord, this discussion with Mr. Chaudhary. I'm very deeply obliged, Milord, very deeply obliged.
12.
Well.
None for the petition. In the interest of justice, adverse orders are deferred. List after 2 weeks. List of monthly list January ka to. Monthly list of January.
My application, Milord, under section 34, sorry. Under section 34, challenging a part of an award passed by the MSME Council.
Within 120 days?
Yes, ma'am. Within the period, and challenging it, the award is in my favor. So there is no deposit of section 19 that is required. It's just that it allows the principal component. For some reason, the interest bit of it doesn't allow, saying the interest I can't allow because of X reason. The solitary point that I had, that interest is, once the principal is payable, interest payment is a statutory mandate under section 16 of the MSME Act. Then it is not left to a discretion of the tribunal anymore. Of course, I'll try and canvass before your lordship that the exercise of the discretion is also contrary to law. Now, because it's ex facie contrary to 16, I come under as a ground of 34. It's contrary to law. If I just show that one provision, my lord, there's nothing that I need to trouble your lordship with at all. Service kothay? Affidavit service kothay? Ye to original ta kothay?
Affidavit service?
It's filed on the last day. I'm told we've served, not. I haven't personally checked. Serve করেছি তো?
They are served.
Yes, when it was delivered on 18th of November of this year.
Delivery is not there.
I'm sorry, Milord?
Oh.
There
he comes.
Finally.
Take
your breath. Take your breath. I'll take 2 minutes.
Let him speak.
Milord, if your lordship looks at the MSME Act once, please have a look at section 16. Milord, I'll take your lordship to the facts and everything because it will have to be heard.
In the last matter, Mr. Gupta was here.
Mr.
Gupta was here.
John Gupta.
Yes. Can you call him? I want that. I see the. उसको बुला के एक बार.
Well, I'll have him come before
Yeah,
you.
please, can you ask him to meet?
100%. No?
He was supposed to file something which he has not done.
No, I'll call him. But please have a look at the MSME Act 1, section 16. Where any buyer fails to make payment of the amount to the supplier as required under section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any law for the time being in force, be liable to pay compound interest with monthly rest to the supplier on that amount from the appointed day, or as the case may be, from the date immediately following the date agreed upon, at 3 times of the bank rate notified by the Reserve Bank. Well, the award is in my favor. If your lordship looks at 18.4.
But how will this help you while the arbitrator is granting the interest?
I'm sorry, Milan?
How will this help you while the arbitrator is granting interest?
Well, when the arbitration is happening, the tribunal is...
This is a different clause.
Well,
you will not be covered in this. How will you be covered in this?
Well, I'll tell you, Lordship. Kindly have a look at 18.4.
Where the mediation initiated in section 3 is not successful and stands for Yes. Yes.
Subject to what falls from your lordship, I've just had a word with my learned friend as well. I am also in the process of filing a section 34. Both of the parties are aggrieved by the award. My section 34 is coming up next week. Subject to what falls from your lordship, since both the parties...
reply in this one.
Very well, lordship, I'll file.
Yeah, he'll get that breathing.
On different grounds, but your lordship, I am also challenging the award on different grounds.
Okay, he will file his reply on that.
Very well, lordship.
We'll hear both. Basically, affidavit is just to put everything on record. I mean,
Very
it's
well,
not like you're
lordship,
making any new submission or you're putting anything.
Which is why in the last matter I said I won't give an affidavit.
Correct. In one of the matters also, if the pleadings are complete to the extent that the entire arbitral record is here.
Lordship, that will...
You know, in Delhi High Court, you can't file a 34 petition without giving a certificate actually that entire arbitral award is or the record is on record. I mean, here
it's most of the time, at least in these matters, it becomes pointless.
And then again, you know, your 36(2) application comes without the award.
Right.
So, like, if you want to refer something and see it, separate petition. So, gets difficult for the court. Anyway, the petitioner has preferred the present petition under Section 34 of the Arbitration and Conciliation Act, challenging the award dated 16/4/2024 passed by the West Bengal Micro Small Enterprise Facilitation Council. Full stop. Learned counsel for the petitioner states that he had received the award on.
I'm sorry, my lord.
When did he receive the award?
We received the amount on 19th of August 2025.
19th of August 2025. And the petition is well within
time.
90 days or 120 days?
90 days.
Well within time. Full stop. Learned counsel for the respondent seeks and is granted.
Your Lordship, 2 weeks.
2 weeks? 3 weeks? 2 weeks?
3 weeks, Your Lordship. Makes
3
it
weeks
3
time
will
to
come
file
out.
his affidavit in opposition. List in the monthly list of.
I'll file a reply to that if he's filing that in a week's time.
There is no
not
need to
because
file. This is only to bring it on record. No reply. These are not proceedings.
True.
3 weeks list in the monthly list of January.
Very well, Lordship.
Monthly list of January.
Grateful.
Grateful, Lordship.
When you file it, then we'll tag it along.
Lordship.
And please send Mr. Banerjee. Please send Mr.
I will tell you.
But I am for the petitioner here. Advocate on record on this matter means he's ill due to illness. He unable to attend. I am appearing for not to.
My lords, I'm appearing for the petitioner. My lords, I'm the counsel for the petitioners. I've been instructed to appear in this matter.
Yes, madam.
My lords, this petition is filed challenging the final award passed by the arbitrator. My
Yes.
lords, in this very same matter, there was also an interim order which was challenged before this very High Court and which has been stayed. My lords, may just have a look at that order. That is at Exhibit E.
Exhibit D.
E for elephant.
Yes.
If my lords may just go through the second last page of the order. My lords, that is the important part. My lords, has it, my lords?
Yes.
My lords, the order reads, under such circumstances, the order dated 15th October 24 is partly set aside. The respondent shall not take over possession of the assets. The petitioners are not required to hand over the same.
Just 1 second.
Yes.
Gupta, I want that, that international, that chamber of, that the section 30 which you relied upon.
Yes.
So, can I give me the?
I will ask my solicitors to give it here.
Yeah, please. I'm not able to work further on it only because of that.
I will.
So just hand over that. Thank you. Yes. Yes, madam.
Yes. The petitioners retain custody thereof. However, the secured assets which are in custody of the petitioner shall be retained in good condition and no third-party rights will be created. Inventory as directed can be made by the respondent to ensure that the assets are well maintained. Such inventory shall be made in the presence of the petitioner's representative. The petitioner shall be restrained by an injunction from alienating, encumbering, or creating third-party interest in respect of the assets. And the articles which form part of the secured assets till disposal of the arbitration proceedings. The other direction to disclose the details of the property, bank account, fixed deposit shares, and other receivable is also set aside. In order to protect the interest of the respondent, this court further injuncts the petitioners from dealing with any of the immovable assets, even if they do not form part of the secured assets, till the disposal of the proceeding. So, my lords, this was the interim order which was passed by the Honorable Calcutta Court.
This has got nothing to do with the section 34 petition, madam.
Yes, my lords, I'll come to that. My lords, now the final award which has been passed, which is impugned.
Yes.
My lords, para 9 of that award.
Yes.
My lords, para 9 says the interim order passed during the arbitration proceeding is confirmed and shall remain effective. My lords, the entire award has no mention of this order of the Kolkata High Court. My lords, prima facie, the award is illegal because of the jurisdiction and the appointment of the arbitrator.
My lord, they have appeared
They know about the proceedings. They filed appeal. Order has been modified. Now they are saying
Milords,
that
we have never appeared before the arbitrator. We had filed
This
an
has to be
application.
heard, madam. Whatever it is, it has to be
Yes,
your
ma'am.
filed a 34. It has to be heard.
Yes, Milords.
I think
So
give me
we'll
4
see
weeks
that.
time, Mara. I have to file
The
opposition.
petitioner has filed the present petition under section 30. Petitioner has filed the present petition under section 34 of the Arbitration and Conciliation Act 1996, challenging the award dated. What is the date of the award?
4th April 2020, the beyond 120 days, but I will take a point in my opposition.
This is beyond 120 days.
Yes, my lord. This
No,
is on
Milords,
4th April
I have
2025.
justified in my petition.
Where have you stated it's within time?
Yes, Milords. Milords, para 28 of my petition, which is at page number 11. Milords, the award I have received on 29th of July 2025. Milords, there is a postal tracking receipt to that effect that the award is received on this date. So, Milords, my limitation will start from the date I have received the award.
I will take it out point one in my opposition because I have instruction otherwise, my lord, because the online award has been passed, is already sent by email, and this is already posted in the website of the tribunal. They are aware of the award. In amendment, my lord, I will make submission after filing my opposition on that. Because this is the ODR platform. Whatever
Milords, be that as the case may, Milords, my fundamental grievance is that the arbitration could not have taken place in the manner in which it has taken place. Milords, my objecting application was filed under section 16, which has not been considered, and bypassing everything directly, a final award has been passed.
All right, so we'll hear all this.
Yes, Milords.
Challenging the award dated 4/4/2025 passed by the arbitral tribunal, which the petitioner states has been received by the petitioner on 29th July
2025.
2025. Full stop. Learned counsel for the respondent seeks and is granted
4 weeks time, because during the vacation, Mala is coming.
4 weeks time to file his affidavit in opposition. List in the monthly list of January.
Obliged, Milords. Very grateful.
Good.
Mr. Datta, you're sitting for which matter?
The next one.
Next.
My lord, in 15, I appear for respondents.
Yes.
My lord, I shall be praying for 1 week's time because yesterday only I was had involved with a brief and I'm yet to file my wakalat now, my lords.
You have a gracious advocate
My
general.
lord,
With a smile, he says, okay.
Milord, it so happened, maybe 20 years back, there was an honorable judge, Justice Talukdar.
Yes, yes, I've heard.
Yes. So Justice Talukdar, before Justice Talukdar's bench, an adjournment was sought for by my other side, on behalf of my other side. So the honorable judge looked at me and said, yes, what's your response? So I said, as usual, I said, yes, okay. The honorable court observed that why will you object? You are the beneficiary of this system. So unless there's any pressing needs, it's no. I generally
Not
do
today, we'll have it when you want.
next Friday, my lord, or Thursday.
Next Friday.
My lord.
Keep it in the top. Next Friday in the top 5 matter.
I'm grateful. Huh? No, next Friday.
Next Friday.
Next Friday.
Next Friday. Very
अब क्या बचा आइटम नंबर 1-2 ले लेते हैं yes
My lord, next matter, item 28.
Yes.
I am for the petitioner. The section 9 application, my lord, previous occasion, there was a direction for filing affidavits.
Lordship, I am appearing for this respondent. In this matter, they haven't served the copy.
It has been served in the department. They have appeared. Neither they have written any letter. But you kindly see the previous order. They have appeared.
You had appeared.
And neither they wrote any letter to me, to the petitioner, that they have not yet received.
Lordship,
And
Ministry
what
of Law.
steps have you taken to invoke the arbitration?
My lord, we have taken steps, my lord, but the difficulty is this.
What steps have you taken?
We have written a letter to them and they have given
For
one.
invoking the arbitration proceedings, what steps have you taken, sir? We are not here to deal only with section 9. We have to
No, only
ensure
the
that
interim protection I required, to the
while
extent that they have
interim
legal
protection, you can go get before the tribunal also.
fact remains is this.
What have you done? What steps have you taken?
I have written a letter invoking, but they have not yet taken any decision. I will be filing my necessary application within shortest.
Must. You know, this is section 9 is not a matter of right that you just want
But
to
only
take.
thing is this, my lord. I was illegally terminated. That was not communicated to me.
Sir,
and now they are
whatever it is, go before the arbitrator. These 9 petitions can't be pending over here like this. Let her file a reply. Yes.
But the only thing, my lord, they may liquidate my fixed security deposit.
The court has already considered that aspect.
But that was not considered. Only the thing was which was considered the termination, which was not served upon us even.
Let her file her reply. Learned
In that case, I will again serve a copy. If this wants that, I will again serve a copy.
Give a copy. Learned counsel and file your reply positively. Learned counsel for the respondent seeks and is granted further time of 2 weeks to file her affidavit in opposition. Reply thereto, if any, within 2 weeks thereafter. List after 4 weeks. List in the monthly list of January. Monthly list of January.
I beg to appear on my lord. I beg to appear on behalf of the petitioner, my lord. Only prayer
after long, Mr. Raghunath.
Lordship. But I've seen Lordship while my lord, the deliberation was going on a occasion memorial lecture. Lordship was sitting in the first row.
Yes, I was there.
I had the opportunity to, my lord, hear that.
You were there or
no? Not
just
here.
watching it?
That YouTube. My lord, what happened here? My lord, the arbitrator was appointed 18/12/2023, first sitting on 24th January 2024, and thereafter, my lord, there is no sign of conclusion of this arbitration proceedings. When the arbitration, my lord, the appointment of arbitrator application was before the honorable court, we people come forward and, my lord, take this particular stand. Yes, there must be an arbitration. There is an arbitration clause without raising any question of appointment of arbitrator. Now, my lord, what happened? Since 14/5/2025, matter adjourned at the behest of, my lord, the arbitrator was, my lord, reluctant. I am not here, my lord, to make any adverse comment against my colleague. But we are helpless now, as a result of which, my lord, we are praying, my lord, beseeching, my lord, let there be a new arbitrator. And the, my lord, the work which...
The scope we are challenging for, it's a 14 application.
It's a 14. I know your lordship's judgment, my lord. I have gone through it. I'm carrying it as well. My lord, there is no question of bias in the, my lord, petition. The only ground that they have taken is delay. And it's in the stage of where the claimant's witness have been examined in chief, cross-examined. Respondent's witness have been tendered evidence, affidavit of evidence, and was being cross-examined. So perhaps the mandate is going to come to an end sometime in January 2026. So if they would not have taken adjournments on the ground of pretext of this 14 since 17th of September, perhaps it would have been completed by this time, or the arbitration proceedings could have been completed by this time. And in fact, from their list of dates, your lordship can find from the pages that they have annexed. If your lordship kindly sees only one, the petition that they have filed, they have only themselves said that they have taken adjournment after May 2025. If your lordship kindly takes 2 dates, 1st of August 2025 and 5th of August 2025, which is at page 8 of the petition. They themselves have admitted 1st of August 2025 and 5th of August 2025. They themselves have admitted that they have taken adjournment on
the accident took place, so far the learned advocate was concerned.
And the thing is that 16th of September 2025, on the pretext of this 14 application being pending, the matter was adjourned. 10th of November 2025 and thereafter 21st of November 2025. By this time, we would have completed the plea. There is no question of bias which they have raised.
No, we have not raised. We have not raised the question. But the thing is this, my lord, after this
ground in 14, what 14 is very limited.
Very limited. Only
But-
delay is what
my
they
lord,
have
delay is the main ground here. So far this application is concerned. My lord, what happened? My lord, in the even this particular arbitrator continues.
14 days, on the ground of.
My lord, I am reading, my lord, 14.2. If controversy remain concerning any of the ground referred to clause A, subsection 1, a party may, unless otherwise agreed by the parties, apply to the court to decide on the termination of the mandate.
You please
My
have
lord,
a look at my judgment also. Please
I'll
give a copy. I think I have taken a view on 14.
Yes, my lord, your lordship has. I am carrying it, in fact, my lord.
Give him the citation, please. And then we'll hear it.
on Monday, my lord, because of my lord arbitrator, my lord, they are preponing and all these things. At a point of time, if it was taken place in such a fashion, we have no objection. But now, my lord, when we have filed this application, preponing application is there to conclude the arbitration proceedings and all this.
So then, what is the point of pressing this? If the
Yes, my lord,
preponing
that citation, my lord, I am seeking, my lord,
take
from my
that and come back, and you'll see my view. I'm
lords.
very clear.
On
on
Monday, kindly fix it on Monday, my lord.
My lord,
Before that, I intend to take the
the
citation.
arbitral proceedings are
Not
fixed
today.
on yes, my lord, it's fixed on Tuesday,
Monday.
where they have to produce their witness.
We'll
But
have it on Monday.
I'm great. I'm great.
Not today. We'll have it on Monday. Please have the
Only, my lord, indulgence, my lord, I intend to get the copy, my the citation.
He's
I will, of course, I'll send it to him. I'll send it to him.
Deeply obliged.
Monday, not today. The rest of the matters tomorrow.
Lots.
I mean Monday.